and accounted for. All right, we're good. All right. Hello, everyone. Welcome. We are set for our
Yes.
board meeting. I do declare a quorum at this time. Now we will start the agenda with the question of whether there is any additions to the agenda. Or additions, sorry.
Mr. Chair, can I just
Yes.
recommend that we come back to this in a minute? I know another
The
board member might
additions?
have something. The additions to the agenda. We just move on to the minutes and then come back.
It's totally fine. We also have a section for new business if they wish to bring it up at that time. If not now, it's totally understandable. Thank you for that, Member Weissman. With that, we are moving on to approval of the minutes, the open meeting for May 29th, 2025. Are there any questions, concerns, edits, recommendations pursuant? All the members have an opportunity to review the minutes.
Yep.
No? Yes. Member Weissman,
Move to approve.
is there a second?
Second,
Properly
Jackson
seconded
Stanley.
by
Jackson
Member
Stanley.
Jackson Stanley. Thank you very much. All those in favor, please indicate by raising your hand. All right, so moved. Moving on to the closed meeting minutes. Did all the members have an opportunity to review those minutes? Are there any edits, updates, questions? At this time, thank you. The chair is open for a motion to accept the closed meeting minutes.
I'll move.
So moved by the vice chair. Is there a second?
Second.
Probably seconded by Member Weissman. All those in favor, please indicate by raising your hand. All right, unanimously approved. Thank you all very much. Now, moving on to the state administrator's report that will be brought to us by Katie Berry, I believe, the assistant state administrator.
Thank you, Chair Summers. Just wanted to make sure everyone can hear me.
Yes.
Yes.
All right, thank you. So our state administrator's report, we are kicking off with some important information. We are working to implement a program for Constitution Day at the local high schools. Just yesterday, we sent out letters to all 24 boards of educations to discuss what the education article 7-116 explicitly states, that a Constitution Day program for education to explain the opportunity to register to vote and to coordinate voter registration activities with high school students to increase civic engagement. So we are really excited about this opportunity and looking forward to engaging with our boards of education on this program. We also are in the beginning stages of talking with the Maryland Department of Service and Civic Innovation so that SBE may begin to work with a student or I guess a previous student for the service year option program. And we are looking forward to having them come in to work in the candidacy and campaign finance division where they will be mentored by the agency's leadership. For candidacy and campaign finance, so in late May into June, we had 34 new committees that were established. The pre-election general report for the Prince George's special election was due on May 23rd. The 2026 election, we have had over 112 candidates file so far. And on June 7th, Alan, the director of campaign finance, Nii, who is also part of the campaign finance division, and Ebony led a virtual party central committee training for about 20 party chairs and treasurers with the Maryland Democratic Party. So we are working through having a more robust community outreach program as it pertains to the MD Chris system, as well as the candidate filing process for the 2026 election. The MD Chris and business disclosure replacement update, we have been working through the implementation with our vendor. The staff are meeting twice per week for gap analysis sessions, and we are still on schedule for a full implementation in November of this year. The staff are also organizing, like I said, the training sessions for stakeholders, and we are looking forward to having some of our first trainings upon implementation in November. In public financing, we currently have 31 actively public finance committees, and there is one candidate for county executive in Baltimore County, 3 candidates in Montgomery, and let's see, Howard County has 5 new committees for this election cycle. As of June 10th, there is a little over $10 million in the State Fair Campaign Finance Fund. Under enforcements, there was a total amount collected of $6,550. The particulars of that is listed in the administrator's report. Election management and compliance, we are working through the annual inventory process. 17 local boards have completed 100% of their physical inventory, and we are on track to meet the Department of General Services deadline in September. We also are working through having portable battery backup stations that will be utilized in the event of a power emergency at polling places across the state. We also are happy to share that we are in a design and layout process to update our website. This is elections.maryland.gov. The design and layout has been approved, and we are working on simplifying language, doing some streamlining, usability studies, and making mobile compatibility of our website. So our goal is to have this all implemented before the 2026 election. We also are working through an implementation of to centralize our statewide pollbook database, having a full disaster recovery capability that is expected to be completed in the fall of this year as well. We also continue to work through the governor's interim guidelines with regards to using AI and responsible use of that in elections. So we have some training that many of the staff are undergoing right now, and we are working in accordance again with the governor's interim guidelines. With regard to personnel, the Charles County Board of Elections will soon begin recruitment for a director and a deputy director. Our current director and deputy have recently announced their retirements. That will occur later this year. So there will be some overlap in the director position and to onboard a new deputy director this fall. In addition, we would like to welcome Brandy Underwood as the new deputy director in St. Mary's County. She will take a little bit of time to overlap with Susan Julian, who will also be retiring this year. The Allegheny County Board of Elections just recently selected a new election director, Wendy Maddox. She is currently training with the current election director, Diane Lobel, who also will be retiring this year. So we would like to offer congratulations to all of the individuals that are retiring. They have spent many years in local boards and have been a valuable asset with a lot of institutional knowledge. So we wish them all the best, and we are looking forward to working with all of the new individuals. And I should note that some of these individuals that are coming on board are already in the local board, have institutional knowledge, but we will be working closely with them and helping wherever we can. In other personnel news, we also are working with the Baltimore City Board of Elections, who will be conducting interviews very soon for the election director position. So more to come in August. We'll have even more good news and information there. Under procurement, we are actively reviewing evaluations for the poll book modernization project. The voting system RFP was recently released and is available via our website. You can locate the RFP for the public review. That is out on the street until about the middle of August. And then we will begin the evaluation process for the new voting system. TextSecure, we received 3 proposals and we did award a contract to Democracy Live. So we will be again offering a TextSecure solution for our mail-in voting as an option. With regards to usability services, we are working with CCD to review several documents for the election judge manual, election-related forms, and also SBE's website to ensure usability. And we have a couple of retroactive modifications under procurement, as well as some options period with regards to election staffing and transportation of voting equipment. And more details can be found in the administrator's report. With mail-in voting, I wanted to report that 91% of the voters who voted in the special general election in Prince George's County voted using a mail-in ballot. And under internal audits, the monthly audit of voter registration data continues to be verified for compliance. And right now the focus is on potential duplicate voter records that were in the 2024 presidential general election. Referrals will be forwarded to the Office of the State Prosecutor, and then it will be up to OSP to conduct their investigations. We are also working on the ERIC Voter Participation Project. This is a comparison of ERIC, or by ERIC, of voting history across states. So if we get any further information that needs to be triaged from other states, we also will forward that information to the Office of the State Prosecutor. In the administrator's report, we also have some more detailed information. We had an inquiry regarding some statistics that we provided in a previous board meeting about provisional ballots. We had worked through to the local boards to get more information from voters in 2024 about, if they received a mail-in ballot, why they didn't vote their mail-in ballot, and they went to vote in person. Some of that data that we received, it was not part of the election judge manual at the time. And we were working off of just, data that was provided on the day of the election. And right now we are in the process of revising our provisional ballot application to capture additional data from voters who were marked as mail-in voters, but then came to vote in person. So we also are planning to conduct a large public service announcement campaign next year to help to continue to educate voters if they select mail-in voting and why they should not come and vote in person, so that they don't have to worry with a provisional ballot. The administrator's report does have more data about the reasons that people voted provisionally in the 2024 election. In election operations, our election operations team is working to implement new legislation. From 2025, we have many priorities going on right now. And one of the biggest ones is to transition from having a manual audit post-election to having a risk limiting audit. So more details will be coming in the coming months, and we will be able to provide more information once we have secured a solution and have regulations drafted. Regarding post-election audits, we have completed phase 1 and 2 of Clear Ballots audit for the special general election. And the discrepancy between the two independent tabulations was found to be 0.005%, which is well below the 0.5% threshold. In voter registration, they have updated the voter registration distributor manual, and this has been provided to the local boards of elections, and it is available now for wide use. The training is going to expire on December 31st following general elections, in hopes to have the distributors of voter registration applications get retrained and be in the know of any updates or changes that occur during the 90-day session, or if we have other forms that have to be included with voter registration. The format of the voter registration applications has also been updated. It looks like all of SBE's other public-facing forms. There were no substantive changes to the form, and the form was made in this format to be more user-friendly. As of June 13th, we had a little over 4.3 million active voters in Maryland, and other statistics are on the administrator's report. There were no delegated duties that exercised in the previous month. And with that, Mr. Chair, I'm submitting our administrator's report.
Thank you very much, Deputy Administrator Barry. Are there any questions regarding the report? Vice Chair Shallot.
Thank you, Mr. Chairman. Katie, again, you do a great job. Thank you for all you do. A couple of questions. My recollection is the poll books are geared to start the new ones in the election for 2026. Is that correct? Or
No,
2028?
Right. The poll books and the voting system are both targeted to be 2028's election.
Okay. All right. In that regard, I think I know the answer, but I just need a definition. When you say there's an RFP for the new voting system,
Yes.
what is that? I think I know, but I don't know.
Sure.
What's an RFP?
Yes, it's the request for proposals. So following state procurement law and regulations, informational packet has to be provided to allow for vendors to submit a proposal. And it goes through all of the requirements and preferred requirements of a new solution. So it is publicly available and there's a link on our website that will take you to that RFP.
Has anybody applied yet for that system? Any companies, any vendors, or not yet?
It just went out on the street, I want to say like 3 days ago. So I am not aware, and I can't share anyway.
Thanks. And last question. Regarding all these new directors and assistant directors at the local boards,
Yes.
which are the keys to our success, the local boards, they run the engine room, and we're very grateful to them. When you say the boards are interviewing, do they have the discretion to interview whoever they want, or do they get a list from their county or the state as to who meets the requirements to be interviewed? Do you know what I'm saying? In other words, do they
Yes,
get...
Thank you for the question. So 20 of the 24 local boards of elections are state employees. The position has to go through the official state hiring process that anyone would as a state employee. It is a very strict process that has to be followed. The applications come through SBE's HR division. They are, ranked and evaluated. And then for the election director position, the local board is responsible for conducting the interviews following the state's interview process. There are 4 local boards that are county employees. So they have to go through a separate kind of hiring process. However, the State Board of Elections, the state administrator does have to play a role now with a recently passed piece of legislation that also included the election director evaluations So the state administrator has to be a part of the interview process for the election director. As far as the deputy directors, typically it is the election director that is hiring the deputy director. And that is not in the purview of the local board members.
So the interviews for the directorships are limited to the names that they get from the state or the county, correct? In
Yes,
other words,
that's
they
correct.
don't, okay,
Yes.
that was my question. Thanks, Katie.
Yeah, you're welcome. Thank you.
Thanks.
Thank you, Vice Chair. Thank you, Deputy Administrator, for that exchange. Member Butler has a question.
Hi, it's not really a question. I think I talked to Katie a little bit about this with the different, all the different directors that we're hiring, and that, there might be, behooves somebody along the line to come up with some kind of training for up and coming employees to kind of move them towards being directors, because we're losing so many at one time. And Katie and I did talk about that a little bit, because, someone had called to talk to me about the Baltimore City one. And each process is different, but I remember when we were on our board working with Guy, one of the things that we suggested to him was to start working on moving people up in positions so that they would want to stay with the boards and stay, working towards a higher position. So that was just my little comment for that.
Thank you.
Oh, and then one more fast comment. If 91% of the voters for Prince George's County special election did it by mail, maybe we should look at not having as many early voting days. I know, I think there might be legislation, but to have 5 or 6 early voting days and a regular voting day, and 91% of them are done by mail for the special elections, because I think the cost for PG County right now has got to be horrendous because they keep have these rolling special elections. Just a
That
comment.
may be something to look into, but I appreciate it. I think it was 91% of those participating, not so much about the voters. So thank you very much for that. Member Weissman.
Thank you, Mr. Chair. And yeah, I think that's a statutory issue, to Ms. Butler's last point. Just a couple quick things. And Ms. Berry, I feel like every time you're here, Mr. Demarinis says, and I make some joke about how much happier we are about that being the case. So I wanted to get that in there so that way while he's watching from wherever he is, he can enjoy it. Great report. I'm especially excited about the updating the website. I'm really excited to see where that goes. I did have to bring up, like I do every month, about Chris. I'm glad to hear it's still on track. I'm glad to hear we're still in November. There was a June 25th demo. Can you or Mr. Norfleet it was mentioned in your report, can you just touch on what that was?
Yeah, so I'll start, and Mr. Norfleet, you can add in any additional things. They had demoed basically from start to finish what their mock-up website is going to look like. I was part of that, and I can say that it is very user-friendly. I think, intuitive, and there's a lot of things that I think everyone is going to really enjoy. The vendor is very responsive to making changes that are needed. Mr. Norfleet's team, working through a gap analysis, they have done an incredible job of just staying on top of the vendor and making sure that things can be implemented. So we are really excited for when this is going to roll out. But I think, Alan, would you agree? I feel like we are in a really good position and posture, and like almost there right now. So lots of testing is going to be done. And I would hope that everyone is going to be really happy with the end product.
Yes. Yeah, I can speak to, so we went through registrations for candidate committees, PACs, super PACs. We also did business disclosure registrations. We have lots of tidbits of, like, there's buttons to check the law, like make sure they register as the right type of committee. That's a problem in the system at times. So it's going to be way more user friendly. I think Katie mentioned it looks cleaner, modernized. I think our filers will be very happy. So we're very excited.
Awesome. And you're talking about user friendly. I know you're talking about all of our hardworking treasurers and chairs out there. But I'm assuming you're also talking about members of the public who want to look through reports and want to look through contributions and expenditures.
Yes, well, we haven't went through the public site yet, so that will be probably the next step later in the sprint. But yeah, we'll make sure it's very user friendly. We have started in our gap analysis going about what data might be available so that the public can kind of see what's happening, the flow of money in our elections.
Sometime before November, but no later than November. Thank you both very much. Thank you, Mr. Chair.
Thank you, Member Weissman. I appreciate you, Deputy Administrator and Alan, Director of Candidates Campaign and Campaigning, for your responsiveness to that query. Member Jackson Stanley. Yes.
Thank you, Mr. Chair. Wasn't going to ask these questions, but in the scheme of things, for clarity, I wanted to make a comment. First, Katie, thank you so much for doing an outstanding job interpreting the report for us. I was really impressed with the idea of taking, what do you call it, Constitution Day to the schools.
Yes.
You can't start too early getting our
Right.
kids excited about voting and understanding why they should vote and how they vote. I thought that was a very good concept. One comment, when Jim asked about what is an RFP, being an old state employee, I knew RFP, I knew what it meant, but I didn't understand under campaign financing what PF meant. I think I know, but what does that mean? PF. I saw it a couple of times.
Request for proposals.
PF is request for proposal?
RFP.
No, I know RFP. The
Oh.
initials were PF. I thought it meant public financing.
Oh, yes. I'm sorry.
Yes.
In the report, public
And
financing.
yeah,
I apologize.
I thought I knew what it's meant, but I wasn't sure. And the last is a question. In reading the report, and believe it or not, I do read everything. I saw that one of the things that you can claim for under voting, that you can change your vote 0.2% or less than 2%. You can change your vote. Zero, it was 0.2%. And I just wrote, you can change your vote. I didn't know you could do that. Anybody else see that? I like the minutiae, Mr. Chair. I think.
Mr. Chair.
Understood. Member Weissman, you
Yeah,
want to respond to that?
Yeah, to clarify, Jackson Stanley, I think you're talking about in the provisional ballots.
Yes.
And it's the reason given. It's
Right.
not that they are able to successfully change their vote. It's that this is the reason that they give the judge that they are requesting a provisional ballot.
Okay.
Is that right, Ms. Berry? Am I understand that correctly?
Yes. Thank you, Member Wiseman.
And I thought, I didn't know you could change your vote, but under the
Yes.
provisional ballot approach, you can say, well, I voted for Vicky, but I meant to vote for Diane. That you can do that?
People can
You can-
vote provisionally, but that doesn't mean that their ballot is necessarily counted. So,
Okay.
yeah.
All right. And that was my really only question. I lost you. Hold on. Can you see me?
So, yes, we can.
Okay.
So
I
I don't
lost you
think
guys.
so if we can clarify here, I don't think it's based on the vote, it's the method of voting.
The method of voting. Okay.
Okay.
And I wasn't going to ask I was going to do it.
I don't want
quietly.
anyone out there to hear that, or think that votes are being changed or people are like, no,
And
it's
it was
the
and it was
methodology on
a
how
minute-
they cast their
on my
vote,
new percentage, but it just struck me in my reading. It's like, what?
on how they cast their vote.
How they cast their vote. Okay, thank you. I
All right.
apologize for delaying the process, but I figured I'd rather ask a
Okay.
stupid question and get the right
No,
answer
that's a
than not
great
ask
question.
at all.
That's a great
Okay.
question. No,
All
no.
right, thank you. Thank you.
Thank you for the
Katie.
question. Thank you for the clarification. Thank you, Member Weissman, Deputy Administrator, and I appreciate your question, Member Jackson Stanley. I'm sure others had that very same question. Now, with that being said, we're moving on to Dan Corbin, our assistant. Oh, thank you, Katie, very, very much for your report. Moving on to, per the agenda, Dan Corbin, Assistant Attorney General's report.
Thank you, Mr. Chair. Just making sure everyone can hear me. Sound check.
Yes.
Okay, good.
Yes.
Your Assistant Attorney General's report looks a little bit like past months with some new changes. It's kind of like the weather. The first two cases, there are no changes. Sullivan v. Summers and Della Rocca v. Lee are both still awaiting action from the court. Sullivan v. Summers, is essentially concluded, and you'll see that in one of the regs that you're reviewing in this month's meeting. We're just waiting for the case to be formally finished with a dismissal by the court of the outstanding counts that neither we nor the plaintiffs need addressed by the court. Della Rocca v. Lee, the defendants, both the state defendants, OAG has filed a motion to dismiss on behalf of Secretary Lee and Chairman Summers, who is named as the defendant in the case. And the Department of Justice has filed a motion to dismiss on behalf of the Postmaster General. Both of those motions are fully briefed out. The other side, the plaintiffs, have responded to them. We're awaiting a decision from the court on both motions. The cases where new things have happened and the new cases. California et al. V. Trump. This is the case filed by a consortium of 19 states against federal officials to stop and enjoin the executive order issued by the White House on elections, or certain provisions within that executive order. On June 13th, the court granted our requested preliminary injunction. So the states have prevailed on their motion for preliminary injunction. What that means is, while the case is going, the case is not over. A preliminary injunction is a tool in which parties come to court and say, hey, while this case is happening, freeze things in place and don't let the thing that we don't want happen until you decide the end, right? And so we asked for a preliminary injunction enjoining execution of certain provisions within the executive order, specifically those having to do with documentary proof of citizenship for the EAC common form and for the federal postcard form, and for election day for directing the DOJ and EAC to take certain actions if a state permits counting of mail-in ballots after election day. The court enjoined them. So they are currently not in effect. The only other thing to add, since there's been a bit of news, is that the Supreme Court decision about universal injunctions does not affect Maryland in this case, because Maryland is a plaintiff. It is a party to this litigation. And so the preliminary injunction continues to cover Maryland. The executive order is not enforceable right now, or is enjoined in Maryland. The next case, number 4 on the list, and I'll if it's okay with the board, I'll take any questions at the end just so we can get through the cases. The 4th case on the list is a new case, Bryson et al. V. Moore et al. The plaintiffs are 5 registered voters who are not affiliated with a political party in Maryland. They are unaffiliated voters. The defendants are Governor Moore, the State Board of Elections, Chairperson Summers, and State Administrator DeMarinis. So election officials and the governor. And the allegation is that it's a civil suit to enjoin the state board from organizing, conducting, or funding a primary election in which unaffiliated voters are not permitted to vote in the Democratic or Republican primary. The complaint was filed in early June. The OAG will be representing both the governor and all the election officials, the election community in Maryland, and a responsive pleading. The response from the state government is due before July 30th. That's in the Circuit Court for Anne Arundel County. So we'll be responding within the next month to that case. The last case, I'm actually happy to report, has had another update since I wrote this report. Wilbur Friedman v. the Maryland State Board of Elections. This was a suit about a late penalty or late fee imposed for a late campaign finance report. It was filed in the Circuit Court for Montgomery County. I'm happy to report that since it was filed, Mr. Norfleet helped me kind of understand what was going on and worked with me to work with the plaintiff in this case towards a settlement. I wouldn't really call it a settlement because the plaintiff and I reached an understanding that he owed a $650 late fee, not a $1,000 fine, which is what he alleged in his complaint. Since then, he has paid the $650 late fee. CCF has received the payment, and he has voluntarily dismissed the case since there is no more any case about it. So that is the first and only time that you will see this case on the report. It has come on, and it will be coming off before next month.
Thank
And
you
with
for
that-
your new arbitrary facilitation there. Your new arbitrator. Excellent.
This, once the
I'd like to go that route, Dan.
if they could all only be that cooperative and understanding and we could work them out like that, it would be wonderful. And with that, if there are any questions about the California EO lawsuit or the primary election litigation, I'd be happy to take them.
Totally duly recognized, Vice Chair, for your question of
Thank
the
you, Mr. Chair.
Assistant Attorney General. Yes, sir.
And question, on the lawsuit where unaffiliated voters are suing to be allowed to vote in the party primaries, Republican and Democrat, who makes the decision as to what our answer is? I mean, do you consult with the Democratic and Republican Party chairs? Is this a political decision or a legal decision? In other words, who decides what our response is in a political case like this?
So that is an excellent question. And let me start out by answering. I do not, and OAG does not consult with the Democratic and Republican Party about what the state's answer is. The Democratic and Republican Party may have their own interests in this case. And if they want them kind of vetted in court, they'll have to bring them to court. The kind of technical legal point of view here is that what the plaintiffs are suing about is a law in the election law article. It's 8202, which says that the principal parties, the Democrats and Republicans from our last gubernatorial election, must have a primary in order to select their nominees. And only if they permit unaffiliated voters and inform the state board that they will permit those unaffiliated voters, then unaffiliated voters can become involved. But if they don't permit it, it's a closed primary. And historically, I don't think there's ever been an election in which they've permitted it. So what the plaintiffs in this case are doing are suing and saying there's two unconstitutionalities in the law right now. One is 8202 even permitting a closed primary and having the state pay for it, right? So OAG makes the decision about whether and how to defend a state law, here it being 8202, and OAG will be defending the state law as constitutional in this case.
Well, shouldn't the appropriate defendants be the political parties then? I mean, the law says that they can decide it.
The law says that they can decide it, that's true. And there may be an issue in the case about the deadline for them deciding it, which is 6 months before a primary. So if for the first time in historical precedents, they do want to allow it, they still can. However, if they decide to have a closed primary, the law requires it to be closed. And so the Office of the Attorney General, on behalf of a state office, the State Board of Elections, is going to defend the constitutionality of that law.
I see. I'm just missing a step here because it seems to me that the existing law allows the Democratic and Republican Party to decide who votes in their primaries.
It
So,
does, but
shouldn't they be sued?
Shalek, do you want to help me write the motion to
No,
dismiss?
no.
You may be onto something, but a brief answer is that one of the key components of their complaint, which is public record, I'm happy to talk about it in this meeting, is that they make very clear in their complaint they are not alleging that they want to vote in those primaries. That is not the remedy they're asking for. They're asking that the state not fund those primaries. They're saying that once those parties make the choice, the state should not be paying for and running the primaries if it is closed.
Oh, I see. Thanks, Dan. That explains it. Thank you.
Thank you very, very much for that dialogue, gentlemen. Member Butler, your hand is raised.
Yeah. We had a church rummage sale and I had a lady that was very, very involved with all this stuff. And she came up to me and she says, oh, I like that unaffiliated, she's unaffiliated. And I think that's where a lot of this is coming from. The unaffiliated voters want to vote in the primaries. I said, then which primary do you want to vote in? And I said, you just want to pick and choose which one you want to do. So we kind of had a conversation about it. And I think she woke up a little more after just having a quick conversation about how it's it really would be very hard to implement, etc. But that's I think that was interesting also, Jim, what you brought up about the parties having the decision. I'd have to read that law a little more carefully. Thank you.
Thank you. Also, Member Butler, for point of decorum, could you let the half-naked man know you're on a public-facing event? All right, thank you. With that, can we move the agenda forward with regards to our Title 13 late fee waiver request? That would be Alan, our Director of Candidacy and Campaign Finance.
Thank you, Chairman Summers. Again, these are Title 13. These are PACs, parties, candidate committees that are seeking relief for late fees. And I have 7 approvals to waive and 1 denial. And if anyone has any questions for me, I'm glad to answer.
Diane, while you're away, Alan asked if you had any questions, if any of us have any questions with the recommendations for Title 13 waivers. All right, if there are no questions or concerns,
There were some
thank you.
things in
Thank
there.
you. Thank you very, oh, are you good? Okay, yes, it is. There's some information, very interesting information in there. It is public record. It is there for all to see and to review. Thank you all so very much. I will accept a recommendation from the board to accept the recommendations from the state, from the election members.
So move.
So moved. Member Stanley Jackson. Is there a second?
Second.
It's probably seconded. Thank you, Member Weissman. All those in favor, please indicate by raising your hand. It is unanimously approved. Thank you so very much. Now moving on to Title 14 per the agenda. And that would be Director of Candidacy and Campaign Finance, Alan Norfleet.
I have, again, business filers, if they have contracts with the state or they have, or they employ a lobbyist, they have reporting requirements. I have 1 grant of waiver request and 13 denials. And if anybody has any questions, I'll be glad to answer them.
Member Weissman.
Thank you, Mr. Chair. Mr. Norfleet, can you just, I know we go through this a lot because there are a lot of folks out there who are affected by Title 14 and, kind of miss the boat on it. But I got a call this past month and I mentioned something to Miss Berry. When folks get letters that say it's been referred to the Office of State Prosecutor, can you just clarify what this means, how terrified they should be, all that?
Sure. So we send information to the Office of the State Prosecutor that basically says, this individual has been identified as someone that has voted twice. They are given all of the pertinent information that is required for an investigation to occur. Once it goes to the Office of the State Prosecutor, and it doesn't come back to SBE. So
we're talking about Title 14.
Yeah. I Member Weissman, I can answer
Okay.
that.
Yeah.
So
Thank you.
sorry.
no, you're good. So basically there's a time limit on payment to the state or for their late fees. And if it exceeds that time period, we refer it to the state prosecutor. And the next step would be sending to collections to CCU. So that's kind of the flow of things. And I will say Title 14 does struggle with people that file late or they realize their requirements after they sign a contract. So I agree that there is, it's a struggle. And, also part of the law is that the government agencies will be filing with us. In the new system, there will be government agencies filing with us and we'll cross-reference to get, hopefully we can more quickly identify filers that have not registered timely. That's my goal. And I will say we've kind of changed our standard operating procedures. We do a lot of calling of filers and emails. And we get a lot of returned email and letters because, as you can imagine, it's like secretaries, people that have left companies, and no one knows about the filings anymore. So I think that's probably the biggest challenge with Title 14 is that people leave their jobs and they do not update their registrations. So we are on it. We're trying to address that much more than we have in the past.
No,
So
I understand that. I appreciate all that. I think
Yeah.
you and your team go above and beyond in terms of the customer service component of it. The call I got this past week, or this past month, I explained to him, he was all on board with that. It was more just a question of if they get a letter from OSP, OSP is essentially our de facto collections agency.
yes.
They should not assume that they're about to have a prosecutor banging down their door. They should
No.
just go pay the fine and everything's going to be okay.
Yep. And we
Perfect.
if they just pay SBE, and OSP is no longer in the picture. So that's the ultimate goal here.
Perfect. Thank you.
Sure.
Thank you. Are there any further questions? All right. Hearing none. The chair is open for a motion to accept the recommendations of Title 14 waivers. Member Weiss,
So moved.
is there a second? It's
Second.
been properly seconded. Member Butler, thank you very much. All those in favor, please indicate by raising your hand. It's unanimous. Thank you very much to approve the waiver requests and denials per, the request per the recommendation. Thank you so very much for that, Alan. And now we're moving on to the campaign finance entities administrative closures. I think there's one there. If you want to describe what that is, just in case this is not the run-of-the-mill or common agenda item. So if you could just give us a brief overview. I know
Sure.
you've had
So
it twice.
yes, this is one tool that we can use for very unusual circumstances for filers where we cannot resolve the issues for the filer has. And you'll see with these circumstances, with one, both officers have passed away. And so that's the one circumstance. And then the other is a candidate that has went through the legal process of, going to prison and paying restitution, and that is also irreconcilable, the accounts. So it's a very extraordinary measure, and I think these cases fit that mold. And if anybody has any questions for me, I'll be glad to answer them.
Mr. Chair. No questions, just for full disclosure. Dr. Teresa Staffen and I she was my classmate and friend growing up. So I wanted to make sure I put that out there. And her sister and I were colleagues as well.
Thank you very much for sharing that. With that being said, thank you, Alan. Is there a motion to accept the board's recommendation for campaign financing to these administrative closures?
Mr. Chair, I'm
Member
happy
Weissman?
to move, but Ms. Butler has her
It
hand
looks
raised.
like
I
it.
don't know if that's-
Member Butler? I'm sorry, I missed your hand.
I just had a quick question on the second one. So this was it went to court. So this whole $37,000 that the court is dealing with that. Is that correct?
That is correct.
Okay.
Yes.
Right.
All right.
Like to move, Mr. Chair?
So moved. Is there a second? It's been properly seconded by Member Butler. All those in favor, please indicate by raising your hand. So moved. It's unanimous. Thank you very much. And now moving on to accept the board's recommendation. With regards to the agenda contract disclosure waiver requests, Alan, you want to take us through that?
Sure. So this is where business filers are asking not to disclose parts of their contract. And there's particular reasons they can do that. The 3 reasons they can request to not disclose parts of their contract. I have 3 requests. We are recommending to grant them. If anybody has any questions about this, I'll be glad to answer them.
All right, if there's no questions, the chair is open for a recommendation to accept a motion.
So moved.
It has been properly moved by Member Weissman, probably seconded by Member Butler. All those in favor to, please indicate by raising your hand. It's so moved. Thank you. The board's recommendation or to accept the request or disclosure has been unanimously accepted. All right, now moving on to the proposed regulations. Now, we have quite a few regulatory matters that are being proposed, regulations that are being proposed. I would like to take them in groups that
If I may, Mr.
are
Chair.
synonymous.
Yeah,
Um,
so I'm handling regs this month.
All right,
Surprise.
sounds good.
And for the board, for the ease of the board, I propose we do it as follows. You have on both the agenda and the cover sheet line items, alphabetized items A, B, C, D, and E. A is its own thing. B through F are their own group of regs. G is its own thing. And then, I mean, the remainder are essentially their own thing. G is its own thing. H is its own thing. I and J are their own things. For ease of the board's kind of, consideration, I propose we start with A, and then we do G, H, I, and J one at a time. And then we conclude with the package of regulations that are B through F. And so to start, A.
Before you go on, Dan, anyone have a issue with that? I like the recommendation and suggestion, Dan. I really appreciate it. Any issues with that or any questions about that process? All right,
Okay.
sure, Stan.
I'm going to start with A, which is 33.321. This is a regulation in which you are taking something out of COMAR. This is a byproduct or the result of the Sullivan v. Summers litigation, in which the federal district court ruled that 33.321C is preempted by the National Voter Registration Act. And so the amendment to this regulation would be to remove C from COMAR. Right now, the board is not enforcing C because it is bound by a ruling that says it's preempted. This will make that non-enforcement more formal by taking it off the law books formally.
Thank you very much. Member White, Butler.
This is the one that we added in, and then all the lawyers wanted to, to take this back to court to get a ruling on it. And I think that we ought to put verbiage back in that says that is one of the accepted uses of the list. I talked with Dan about this, and he said we could do that, and we could put certain regulation language back in there. I think we could be careful how we do that so that we don't have an issue of somebody going above and beyond board, trying to contact people. But I think because it did become an issue and it was out there, I think putting it back in the regs as an acceptable use, I think it should be left in some way, shape, or form. So we would have to change the verbiage there, but instead of just taking it out, but leaving something in there that is an accepted use.
Understand. At this time, the recommendation is that we strike, and we can always come back and amend at a later date. I appreciate your note, and we will work with the administrator to address that concern going forward. At this time, the regulation or the proposed regulation is to strike the language, and then this goes to public comment and then comes back to us.
So how would that work?
Right now, we're going to take a vote on the proposed regulation to strike the language, to move it forward, to move it to public comment, and then it will come back to us for a vote. If we wish to amend the regulation in the future, per your recommendation and working with the state administrator on that and the board, at that time, we can do so. Okay?
Okay.
All right. Now, the chair, if there's no further questions with regards to the regulation in and of itself as it is being proposed, the chair is open for a motion. Member
So moved.
Weissman, is there a second? It's been properly seconded by Member Jackson Stanley. All those in favor of the recommendation for regulation, to strike, regulation number 33.03.02.01. Is that correct? Did I read the right one?
It's
Okay.
that regulation, it's provision C,
Provision C. Let's see,
3C.
3C. That is indicated at what, where are we
So
on
it's,
proposed regulation? A, it's not A, it's
no, A is 33030201.
01.
And
Okay.
within that section, it is B3C.
Okay, I see it now. All right. All those in favor of the recommendation, of the regulation, please indicate by raising your hand.
To strike.
Thank you, is unanimous. Appreciate that, Dan. Moving on.
Okay, the next is G, which is 33071103. The fun and quickest way to explain this one to you is that you have already approved it once. Back in your April meeting, you approved this language for documentation required for applying to be an election judge, and this was pursuant to a mandate by the General Assembly when it passed a law requiring SBE to set out a regulation for what the minimum documentation was for applying to be an election judge. In the original regulation that you were presented with and that you approved, it originally said under B, either IRS form W4 or IRS form I9. And what was meant was W9, not only I9. And so when we sent it to the Department of Legislative Services and realized that, we brought it back to make sure we had the right IRS forms in there. We've put W9 in there. Otherwise, there is no change from what you've already approved in April.
All right, thank you very much. Any questions? All right. Chair is open for a motion.
So moved.
It has been properly moved by Vice Chair Shalek. Is there a second?
Second.
It's been properly seconded by Member Weissman. All those in favor, please indicate by raising your hand. It has been passed. Thank you very much, Dan, unanimously. And now
Next
we're
is-
going to H, is that what it is?
Yes, H,
All
which
right.
is 33080105-1, which is notice of canvass. This is to essentially update a regulation to conform with best practices in 2025. This is the regulation that requires an election director to provide notice to interested parties, and interested parties in the regulation are the chairman of the central committees, candidates who are not a candidate of a political party, and the state administrator, of when the absentee ballot canvassing is going to start, when those canvass sessions are. The regulation currently requires it be sent by mail, snail mail, and this regulation would add an email, since that is a more widely used and faster mode of communication in 2025.
So it's in addition to,
Yes.
all right, thank you. Any questions? All right, and chair is open for a motion to accept the regulation as proposed.
So
Member
moved.
Weissman, so move. Is there a second?
Second.
It has been properly seconded by members Jackson Stanley. All those in favor, please indicate by raising your hand. All right, it passed unanimously. Thank you very much, Dan. That is for 33.08.01.05-1, correct? All right.
Will be
Um,
item
thank you.
I, which is 33080109. This is specification language. The current regulation sets out that a local board will verify the voting system as provided in a different provision. And SBE here is specifying its regulation to have the most precise language, because what that process does is it tests the voting system for accuracy. And so verify is being replaced with test, and that testing is for accuracy, which is being added to the regulation.
All right. Any questions? Hearing none, the chair is open for a motion to accept. So move, Member Weissman. Is there a second? Probably second, Member Butler. All those in favor, please indicate by raising your hand. All right, we have unanimous consent. Thank you very much, Dan. That is regarding regulation, proposed regulation 33.08.01.09.
And then J is the next item on the list, 33080113. This is about certification deadlines. And so what we learned from the 2024 election is that there should be a more formalized process in place for when certification happens. And specifically, once we're getting close to the end of the canvass period after an election, making sure there's a formalized line of communication between our local boards of election and the state administrator and the state board of elections, because that's the time period in which coordination has to happen to certify statewide results. And so we just want to make sure that there's a formalized process for communicating when the end of a canvass and when certification is going to happen. And so this new regulation sets out that certification cannot happen until after the deadline for receipt of mail-in ballots, to make sure that no local boards accidentally certify a little too early. The law sets out that mail-in ballots can be received up to the 10th day or the second Friday after election day. I'm just making sure certification does not happen before that. And that if a local board or a board of canvassers is how the entity that exists during the canvassing period is not going to certify election results by that 10th day, that's okay. The election law article allows for that. And what the election law article says is, well, they just have to certify within 48 hours of finishing the canvass. This regulation comes in and says, if that's going to happen and you're going to go past that second Friday, you notify the State Board of Elections in writing about why it's taking that long and what the plan is for making sure you certify in the near future. And so that way the state board and the state administrator can coordinate that Board of Canvasser schedule with the greater statewide schedule to get the Board of State Canvassers in certifying statewide results. The State Board of Election keeps the authority under this regulation to modify a plan. So if a local board, or if a Board of Canvassers, I should say, says, yeah, we're not going to meet that second Friday, it's going to take another 3 months, the State Board of Elections retains the discretion, the authority to say you cannot take 3 extra months to certify an election.
All right, thank you. Are there any questions? All right, hearing none, the chair is open for a motion to accept the regulation as proposed. Member Weissman, thank you. So moved. Seconded, probably seconded by Member Butler. All those in favor, please indicate by raising your hand. The proposed reg is unanimously passed. Thank you.
Thank you, Mr. Chair. The last regs for consideration are a bundle. The reason these are being presented to you, these are a bundle of, I believe, 6 regulations. 1, 2, 3, 4, 5 regulations. During this past legislative session, the General Assembly passed a new set of laws, essentially, that were in one bill that re-established how the elections are planned for and how the state board approves those plans. Prior to the new bill, prior to the new law, 3 plans were presented to the state board, and sometimes at different times. There was a polling place plan about where a local board of elections would put polling places and precincts within a county. There was an early voting center plan, which detailed where a local board would put its early voting centers within a county, and then a drop box plan, which first went to the state administrator, and that's it. There was no other review than the state administrators. What the General Assembly did was consolidate that process and say, now, instead of 3 separate plans going at different times and being considered separately, there's going to be one election plan that election plan must have a polling place plan, an early voting center plan, and a Dropbox plan. That there are certain things a local board must consider when it places its polling places, its early voting centers and drop boxes, although those things that it considers are not necessarily, the vast majority of them are not new. They're just placed in a new section so that there's continuity through the code. And that the state board has one approval process for approving an election plan, which has all three components in it. These 5 regs, I believe 3 of them are wholly new. They are written in order to implement the election plan process at the state board, which includes what is an election plan physically, what does it look like, and that's going to be a form provided by the state board. The form itself will be drafted, but I'll give you a sneak peek. It's going to look a lot like a combination of the 3 forms we use now for polling place plans, early voting center plans, and Dropbox plans. It talks about how the election plan is submitted to the state board, when that happens, and how the local board can transmit it. And then the state board's approval process, the timeline for that to happen, what happens if it's not approved. That's essentially putting meat on the bones of what the General Assembly has created already.
And then the proposed regulation you're addressing is 33.01.08.01-04.
Yes,
Yes,
that what I'm
okay.
talking about right now, yes.
But the whole bundle, but yes, that contributes to the rest
That
of
yes.
the,
So
following
the
regs.
3301, 08, 01 through 04 are the brand new, we're not amending something, we're creating new regs to address this election plan thing. The other regs, C, D, E, and F, which are absentee ballots, polling place plans, changing the polling place, and early voting centers, are all receiving amendments to take language out or change language to conform to the language of the new law, and to have to make consistent the state board's consideration and approval process with those specific pieces with the new election plan process. I am happy to go through any individual reg at the board's behest if there are any questions, instead of reading each reg to you over the next hour.
Thank you, Dan. I appreciate that. We had them in a timely manner. I know many of us have discussed and reviewed this, so these regs. Are there any questions? Member Weissman?
No question, I was just gonna make a
Okay.
motion to approve.
Okay, prior to that, so we will be taking a motion to approve the bundle, and I will
Okay.
read them off.
Mr. Chairman.
Or is this
if I
through
may,
04?
So
Mhm.
I believe there's been a speaker has applied to provide.
Right, for public
comment.
comment,
Or-
on this regulation. I was going to take that public comment, after the vote. Due to at that time, these regs are being proposed. And they are being proposed and moved to public comment. So we are putting it through as proposed, and then we will accept this speaker for public comment at new business. Okay?
The board acts at its own
Right.
discretion.
That's yes. We'll accept that to not delay the vote. And so also to receive public comment following the vote for the proposed regulation.
Did the board receive the written
Yes, we did.
testimony from the comment? Okay,
Yes, we already
and so
have.
it's able to consider the written testimony.
Absolutely.
We'll vote. Okay.
Sorry, Mr. Chair, can I just ask, we received several public comment over the last month. Who is the individual? Just so I can make sure I've read the right one.
I believe it's Mr. Adam Gravel.
Yes.
Gotcha. Thank you.
And he will be
Perfect.
addressing us during new business.
Awesome. Thank
So there's a motion on the floor to accept the proposed regulations as stated by the Assistant Attorney General, 33.01.08.01 through 04, 33.11.01.04, 33.15.03.01, and 33.15.03.02 to accept the proposed regs. Is there a second?
Second.
It's been properly seconded by the vice chair. Thank you very much. All those in favor, please indicate by raising your hand. So moved. Thank you. It is unanimous consent to accept the proposed regulations as presented. All right. And now they all will move to public comment for the agenda. And so does that take us through all the regs? I believe so.
Yes, that's all.
All right. Now, per the agenda, is there any old business? No, hearing none. We will now use our new business section to have our speaker address the board. Are they with us? I'm looking to see. Oh, okay, Adam is here. Adam Gravel.
Yes.
Thank you very much, Adam, for joining us. Mr. Gravel, I really appreciate you taking the time. We do appreciate all the work that you have done in this regard to get us to this point. And we are looking forward to your comment. Definitely do appreciate you providing that in writing for us to move forward expeditiously. And we will start the public comment at this time. It is your floor.
Thank you very much. Can I be heard?
Yes, you can.
Okay, thank you. So first of all, just as a preface, my name is Adam Gravel. I'm the attorney who represented 7 individual voters who filed suit in late 2023 following the state board's non-acceptance or non-approval of the Washington County Local Board of Elections early voting center designations. That case was decided in favor of the board at the circuit court level, and the plaintiffs filed a statutory direct appeal to the Supreme Court of Maryland, which held expedited briefing and took a very unusual step of immediately after oral arguments at the Supreme Court, ordered the parties to attend a mediation, which I had never seen happen before at that level of litigation. However, was very gratified that the board, Administrator Demarinis, Dan Coburn, all, in my view, exercised an extreme amount of good faith, and the parties worked together through that mediation to reach a resolution that worked for everybody that year. As part of that settlement, it was agreed that if at any time this regulation 33-17-0202 were to be amended or revised, that the plaintiffs would be provided sort of early access and opportunity to at least be heard on the matter before it was presented to the board. And I do want to thank Mr. Coburn for doing his part to provide access to me as counsel for the plaintiffs in that matter, and further in engaging in somewhat extended good faith discussions about some of the mechanics. And I do believe that to that end, the board did what it was supposed to do as far as providing access and being available to be heard. I am disappointed that the board decided to vote on this before hearing it out or before discussing these matters. However, it's your board and you're the ones who have that authority. So one thing I've greatly appreciated is that in a number of my capacities, I've always been able to deal with the state board and staff and with Mr. Coburn and Administrator Demarinis, frankly, and in good faith, and Mr. Norfleet as well. Has been very good to deal with, and I do appreciate that. And we can sometimes disagree without having to be disagreeable or enemies or anything like that. So I do appreciate that. I want to just briefly touch on the written comments that we provided, that I provided. in regards to, in particular, it's 33-1702. Pardon me while I pull it up. 33-170202-4. Okay. And the proposed regulation, which is now, I guess, approved and submitted for public comment, it says if a county is required by Regulation 01 to have 4 or more early voting centers, ensuring equitable geographic distribution of early voting centers throughout the county. My review is that this is not consistent with the statute, with the new provision of Election Law Article 2303.1D, 4 in particular. D4, for one, all the factors that are supposed to be in place or supposed to be used to select early voting centers have been moved to this provision, and they were largely left intact, except number 4 was changed, and it says, the statute says, quote, for counties with 4 or more early voting centers, ensuring equitable geographic distribution of early voting centers throughout the county. At issue in our litigation was the prior phrasing of the statute was equitable distribution of early voting centers throughout the county. And there was some dispute between maybe the local board, maybe the state board and others about whether equitable distribution throughout the county meant equitable geographic distribution, or whether geography was a part of equitable distribution, or whether other things were a part of equitable distribution throughout the county. And it wasn't clear. And so there was a dispute between the state and local boards as to whether it meant that, and that was part of what informed our litigation. So the statute has been clarified by the addition of the word geographic in this provision, but it also now says for counties with 4 or more early voting centers. That 4 or more was a qualification that did not exist in the previous iteration of this statute. So the proposed regulation, my view of the discrepancy here, or why it doesn't comport with the statute, is that it says if a county is required to have 4 or more early voting centers, then you apply equitable geographic distribution as a factor. But the statute says for a county with 4 or more. In my view, as I put it in my email comments, there is never a circumstance where a county will be required to have 4 early voting centers. The breakdown in 10301.1 is again laid out in the email, but if it's either 1, 2, 3, 5, 7, 9, 11, or 13.
Right.
Those
And
are the only required numbers. The
yes,
only way you get to 4 is if you have an optional site.
right. And I think, Mr. Graff, I greatly appreciate your comments, your points of clarity, and your shared written comments. I apologize. We are getting close to your time. So I am just highlighting that. So if you could
Okay.
summarize, and we are very much aware of this issue and this matter, understanding the 4 discrepancy, whereas 3 are required. If 3 are required and an optional 4th, that is a possibility, but I will let you conclude if you don't mind.
Okay, thank you.
Thank you,
I'll
sir.
wrap it up. So
Yes, sir.
moving on then, I'll just rely on what I put in writing regarding subsection H of that regulation, and I don't believe that it's appropriate to disregard the factors for optional early voting centers for the reasons stated in that email. And then I'll finally note that there's some awkwardness that I think the board ought to consider that a local board is going to encounter when they are submitting a plan. They don't know if their fourth early voting site is going to be approved. So they don't know if they're submitting three plus a hopeful optional fourth. They don't know whether geographic distribution throughout the county is going to be a requirement for them or not.
Excellent.
And
Excellent
so
point. Excellent
the
point.
it would be helpful for them to be able to know in advance. And I do think the board could amend or adopt a regulation that would enable that to be decided beforehand, whether or not you're going to have an extra site, so that the local board knows whether they're applying this geographic distribution factor or not. But if you take the position that it only applies if you're required to have four, then that point is sort of irrelevant. I do think that would be something subject to a proper challenge. And then finally,
Appreciate that.
the regulation 3301-0803, which is the approving or the section that governs the approval of early voting centers. If there's not an approval, if the plan fails to obtain an approval, C1A of that says that the notice to the local board shall include the reason that the plan was not approved. And I would just maybe caution that one of the issues in our litigation that may find its way again is that the board can only act by the vote of a supermajority. And so it may not be clear what the reasons for not approval are. And I think when the board is providing notice of that, the board ought to be careful not to, state something that's not supported by a supermajority. So if three
Understand,
people
Mr.
agree,
Greville.
then
Mr. Greville, I
done.
greatly appreciate it. I did not mean to cut you off. I did ask you, or give you a heads up that we were needing you to summarize. I greatly appreciate the comments. The proposed regulations are out for public comment. We do look forward to working with you through your issues and or concerns. You do highlight matters that I think we are able and have been able to address, specifically to your initial comment, but we are open for public comment at this time as the proposed regulations have been moved forward. We do look forward to continue working with you, with local boards with regards to these issues and or concerns. And that is our posture at this time. I did not mean to have to cut you off, but we greatly gave you an extended amount of time to address your concerns, and we'll continue to work with you as we are in the posture of public comment for the proposed regulations at this time. And we hope you continue to work with our Assistant Attorney General and our Deputy Administrator and Mr. Norfleet going forward. Are there any comments at this time from the board? No, hearing none? All right, thank you all very much. We do greatly appreciate your comments and your participation. Now, are there any disclosure of campaign contributions? Member Weissman.
Thank you, Mr. Chair. Just two of them. Sorry, pulling up the item I put in my calendar to remind me. Or three of them. Donations to Friends of Craig Zucker, elect Eric Ebersol, and the Young Democrats of Maryland. Thank you, Mr. Chair.
Thank you, Member Weissman. Member Butler.
Were we going to discuss this, changing the verbiage in the new business, or where are we discussing that situation? Where we,
Well, we have tabled that because you brought it up
okay,
during the regulatory discussion. We
Okay.
are tabling that to work with you to, because that's a new reg. That would be amending the regulation.
so we will,
So we'll definitely work with you, have you work with the state administrator and or the assistant attorney general and the board to come up with language to address your concern.
Okay, great, thank you.
All right. But also, Member Butler, if you would like to add this for discussion on the upcoming, for the next board meeting, we'll add it in with your, into the agenda as old business for this proper discussion and introduction.
Great, thank you.
Okay?
Mhm.
All right. All right. No other disclosure of campaign contributions. Hearing none. We are now on to scheduling our next meeting for August.
What are we looking at a specific date, Mr. Chair?
We're looking at a Thursday in August for either the 21st, which is the third Thursday, or the 28th.
I can do the 28th. I'm out of town on the 21st.
Thank you, Member Weissman. Other members regarding August 28th.
Mr. Chair, I can do either day, 21st or 28th.
Me too.
All right. Member Shalek, I think he's checking his
Yes.
calendar.
Yes, Mr. Chair. Either date works for me.
Okay, we'll go with August 28th.
August
And
28th?
yes, can we
Thank you.
do 2 p.m. or is 3 p.m. better? 2 p.m. is going back to our
Two,
regular.
2 p.m. is
2 p.m.
great for me. Thank you.
Excellent.
Works for me.
2 p.m. August 28th. All right, thank you for that. There will be no closed meeting today. The chair would like to take a motion to adjourn.
So moved.
Is there a second?
Second.
Probably second by Member Jackson, Member Stanley. Thank you also very much for your due diligence, and see you in August.
Have a good afternoon. Happy 4th of July.
Oh,
Happy
I'm
4th of July,
sorry.
everyone.
Before I do, all those in favor, please indicate by raising your hand.